Good morning. My name is Iris Onassis, and I'm a staff attorney with Lone Star Legal Aid based out of the Conroe branch. This morning, I'll be talking to you about expunctions and non-disclosures. Each serves a similar purpose of clearing a criminal history, which in effect can provide better employment and housing opportunities. This presentation is intended to serve as legal information and does not replace legal advice. Contact Lone Star Legal Aid at 1-800-733-8394 or go to www.lonestarlegal.org for more information on legal assistance. I'm going to begin with expunctions. These are purely a creation of statute. There is no inherent constitutional or due process right to an expunction. These are used to allow those who have been wrongly arrested to clear their records. If one is granted, destruction of all files and records is required. If a person is only investigated for a crime, though, they're not entitled to have the case expunged. Non-disclosures serve more as a second chance. These allow persons who receive deferred adjudication and in some cases even final convictions of a crime to seal their records. If granted, records relating to the offense must be sealed, but certain agencies are still entitled to obtain information concerning an offense that is the subject of an order of non-disclosure. Some examples are law enforcement agencies or some licensing boards. So if you are the petitioner and you had a non-disclosure granted and later you choose to go into nursing or teaching or maybe even be a police officer, the licensing boards will have access to this information. There are 4 types of expunctions: acquittals and pardons, dismissals and no bills, discretionary, and identity theft. Each category does have its own set of rules that must be complied with in order to qualify. The first requirement for any type of expunction is an arrest. There has to have been an arrest that occurred. And this could be either a custodial or a non-custodial arrest. Juveniles, they generally can't obtain an expunction because they're considered to have been detained rather than arrested. So they have to use other avenues to seal their records. That's usually under the Texas Family Code. There are a couple of exceptions, but we won't be covering those this morning. Acquittals and pardons. Any person who has been tried for an offense and was either acquitted or later pardoned is eligible for an expunction. There is an exception if there were multiple charges out of the same criminal episode and the petitioner is still subject to prosecution for another offense out of that same criminal episode. If a petitioner was granted relief on grounds of actual innocence, they are entitled to an expunction. And if this is the case, the agencies will then send all their records to the district clerk, and the district clerk holds on to the records until the statute of limitations has run on any possible wrongful imprisonment lawsuit being filed by the petitioner. If you would like more information about how to apply for a pardon, you can visit the Texas Board of Pardons and Parole website. Quick Google search would lead you to their website. Dismissals and no bills. There are 3 requirements that must be met. The petitioner must have been released and the case cannot be currently pending. The offense cannot have resulted in a final conviction, and petitioner cannot have served community supervision for any offense out of the arrest except for Class C misdemeanor. So if the petitioner received deferred adjudication, they're not eligible. Once those three requirements are met, then the petitioner's case has to fit into one of three categories. The first one is either the statute of limitations has run, so prosecution is no longer possible. Second, the applicable waiting period has passed. No indictment or information has been filed by the time the applicable waiting period has expired. The petitioner is entitled to an expunction, or the case was dismissed for certain reasons. Some reasons the case could have been dismissed for was the petitioner has to prove the indictment or the information that was filed in their case and later dismissed was due to it either being void, the petitioner completed a pretrial intervention program, or there was no probable cause. Discretionary expunctions, these are recommended by the prosecutor, and they have to be made, the recommendation must be made before the person is tried for the offense. The trial court then has the discretion to grant or deny this expunction. There is no guarantee that if the prosecutor recommends an expunction, that the judge will grant it. Last category we'll be going over is the identity theft expunctions. And these types of expunctions are intended to address situations where a person is arrested and lies about their true identity. So the petitioner has to prove that they were not the person that was arrested, and they can do this by submitting fingerprints. The prosecutor has to conclude that the petitioner was not the one arrested. If the prosecutor does not believe that the petitioner has met this requirement, there's no way to challenge this finding. You can't have a hearing and have this be decided by the judge. It's up to the prosecutor. The identifying information has to be false, and the identifying information was given without the petitioner's consent. So they have to provide a notarized statement stating that they did not authorize the arrested person to use their identity. And this is to stop like people who know each other and who may routinely use each other's information to provide to the police. It's intended to address those types of situations. Once the expunction is granted, the district clerk will send a notice to all the government agencies listed in the order. 30 days after the order has been signed and it's considered final, the district clerk must then send a certified copy of the expunction order to all the agencies listed in the order. The agencies must then comply as soon as possible. There's no time limit in the statute, though. Agencies are prohibited from releasing information to anybody. Next, we're going to move on to non-disclosures. These are more offense-based as opposed to arrest-based, like the expunctions, and they're concerned with the overall criminal history. There is an additional requirement of best interest of justice, which allows a judge to deny a request for a non-disclosure, even if all the requirements have been met. Now, there is an important date when it comes to non-disclosures, and that's September 1st, 2015. This is when the non-disclosure statute was amended. So when determining if one qualifies for a non-disclosure, we must first determine when the date of the offense was. Was it before or after September 1st, 2015? Because there are different requirements based on when the offense occurred. If the offense occurred before September 1st, of 2015, there's only one section that has to be considered. And that's section 411.081D of the government code. There are 5 requirements that must be met. The petitioner has to have been placed on deferred adjudication or a drug court or a prostitution prevention program. They had to have successfully discharged and be dismissed from the program. The applicable waiting period must have passed. While on deferred and during the waiting period, the petitioner can't have been placed on deferred or convicted for any offense other than a fine-only traffic offense, and they cannot have ever been convicted of or placed on deferred adjudication for a list of restricted offenses. Now, I wanted to go back to the successfully discharged and dismissed from the program requirement. I did have a case where my client had successfully completed the program, but there was no order dismissing them from the program. And a simple call to the court bringing their attention to this fixed that. The order was signed later that day, dismissing her from the program, and we were able to proceed with the non-disclosure. If the offense occurred after September 2015, they have to meet, there's going to be two requirements they have to meet first. They cannot have been convicted or placed on deferred adjudication for any of a list of certain restricted offenses. And I've included a list here. I'm not going to read them all out, but they're all pretty violent offenses. And it includes the offense for which the person is seeking non-disclosure. They also must not have been convicted or placed on deferred adjudication for any offense other than a fine-only traffic offense from the time of sentencing until any relevant waiting period has passed. Now, once they meet these two requirements, they must then fit into one of the categories of non-disclosures. First category we're going to be going over is the automatic non-disclosure, and this is the easiest one there is. They can only be issued if the petitioner receives deferred adjudication for a misdemeanor that's not found in penal code chapters, and I have those chapters listed out. They are disqualified if they have ever been convicted or placed on deferred adjudication for any offense other than a fine-only traffic offense. There must be no affirmative finding that petitioner is not eligible for an automatic non-disclosure, and at least 180 days have passed since placed on supervision. Now, to find out if there's been an affirmative finding regarding their eligibility for an automatic non-disclosure, usually the dismissal order will have some language to that effect. That's in the case I just spoke about with my client a few minutes ago. The order dismissing her from the program specifically stated that she was eligible for an automatic non-disclosure. So if they're not eligible, it'll state it in the order. Next category is the standard deferred non-disclosures, which applies to anyone who received deferred adjudication for an offense other than one that would entitle them to an automatic non-disclosure. They have to have been successfully discharged and dismissed from deferred adjudication or drug court or prostitution prevention program. They have to show issuance of the order is in the best interest of justice and the applicable waiting time period has passed. Next is straight probation for certain misdemeanors. Petitioner has to have received straight probation for a misdemeanor other than intoxication offenses or offenses that involved engaging in organized criminal activity. The petitioner must never have been convicted or placed on deferred adjudication for any offense other than a fine-only traffic offense. They have to have successfully completed probation or have been released from jail. Best interest of justice prong, again, they must prove it's in the best interest of justice, and the applicable waiting time period has passed. Next, we have the misdemeanor jail time. And it's almost the same as a misdemeanor probation non-disclosure. It still can't be for intoxication offenses or offenses involving or engaging in organized criminal activity. There can be no prior convictions or deferred adjudications for any offense other than a fine-only traffic offense. There must be an applicable waiting period that has passed. And again, best interest of justice must be shown. Lastly, we have human trafficking victims, and this exists only for certain types of human trafficking victims. If they were convicted of prostitution and sentenced to straight community supervision and later had their convictions set aside under the judicial clemency section, they can potentially qualify for this type of non-disclosure. They must be able to prove that they committed the offense only as a victim of human trafficking and that issuance of the order is in the best interest of justice. Does anybody have any questions over anything we went over? Question just came in. Is a lawyer required to petition for this, or can a person do it themselves? No, a lawyer is not required. It's always recommended you use an attorney, though. There are a lot of requirements that need to be made, as you saw, and it can be slightly confusing even for lawyers. So if you would like more information, you can always reach out to our offices or give us a call or go online and apply for services. But if you decide to do this on your own, I know that there are resources out there, booklets and sample forms that you can use to do it yourself. All right, and that looks like that was the only question. I thank you for being here with us today. Again, if you or somebody you know is looking for legal assistance, doesn't only have to be for assistance with an expunction or non-disclosure, please reach out to us, Lone Star Legal Aid. You can apply online at www.lonestarlegal.org. Or you can give us a call at 1-800-733-8394. Thank you.